The Honorable Justices of the Supreme Court. This court, from recess, now seated.
Thank you. Please be seated. And I call the fourth case on this morning's docket. That is case number 104262, State of Kansas v. Raymond Lonnie Ruggles.
May it please the court, counsel. I'm Corey Call, representing Mr. Ruggles. I would request 4 minutes for rebuttal, please.
4 minutes is granted.
Thank you very much. Mr. Ruggles was convicted of 2 counts of aggravated indecent liberties with a child. I would like to correct an error in my brief. At the beginning, I stated that both counts were related to the victim KAB. In fact, there were 2 girls, JLS and KLB. I don't think it makes any difference to the analysis because I'm not making any factual specific claims, but I wanted to make sure the court understood that there were 2 girls involved and not just KAB, as I said in my brief. I'm raising a challenge to the sentence, a constitutional challenge under the 8th Amendment in Graham. As the state notes, there are several different constitutional challenges you can make, factually specific under Freeman, and factual specific under Graham in the 8th Amendment, or a categorical approach under the 8th Amendment. And I'm only raising the categorical. I'm not raising any sort of fact-specific claim here.
And would you agree that this really wasn't this specific categorical claim as you frame it in your brief was not raised at the trial court?
Yes, I would raise that. I would agree with that.
You would agree with that. So yes. The trial court really never had an opportunity to weigh in on the categorical.
That's right. And
analysis here that you're saying that it's the solicitation that's really you're claiming
right.
is the categorical challenge, and the trial court never got into that. It was never even argued at the trial court about the solicitation aspect.
That's correct, and as I understand it, that's not required. It's a question of law. It's implying the fundamental rights of him to have a sentence which doesn't violate the 8th Amendment in the Constitution. And so I don't believe that's a procedural hurdle for me under the category. Under the factual specific, right, sure. It would be because he'd have to make certain facts. But there are no facts here at issue. The key to the argument, as the court noted, is that he was convicted of the subsection of aggravated indecent liberties that deals with solicitation. And so under this crime, there's no actual touching involved. It's just the asking to have sex with, asking lewd fondling. I'm not going to get into the definition of lewd fondling, or touching with another. And so as in my brief, I had a multi-state analysis of the different states, and Kansas stands alone in having a life sentence for the solicitation. The state didn't address that analysis in their brief, other than to note that there were a lot of Jessica's Law cases, a lot of states that have passed Jessica's laws, which is certainly true, but the analysis is a little narrower than that. I think by failing to address it, they somewhat concede the first issue of whether or not Kansas is disproportionate. Maybe I should back up. There's 2 steps to this analysis. First, under Graham, the first is that you look at, is this law out of step with the country and how it goes? Is it disproportionate to what other states are doing under the U.S. Constitution? And if yes, then this court moves on to, let me get the right language here, use its own understanding and interpretation of the 8th Amendment's text, history, meaning, and purpose. And that seems to be that's a pretty general directive to the court to kind of eyeball the statute. And what I would ask the court to look at is the difference between soliciting an act, asking someone something, and actually touching or engaging in some sort of actual sexual conduct with the victim, and that there's a fundamental difference in that. And the courts have recognized that inchoate crimes like solicitation are less serious than the acts themselves in the Kansas legislature to the extent that that's relevant, except in certain circumstances. There's a 3-level drop under, I don't know what the new statute number is, but the solicitation statute, there's a 3-level drop if you solicit a crime versus actually committing the crime themselves. There's just a general recognition that soliciting a crime is not as serious as the crime itself, and it shouldn't have the same penalty, especially when it's severe and out of step with the rest of the country, as life in prison or minimum 25 years.
Do you have any further presentation for us, counsel?
I do not.
Any questions of counsel? I see none. Thank you.
Thank you.
If it please the court, David Maslin, Assistant Montgomery County Attorney, appearing on behalf of the state. We'll go straight to the disproportionate argument, because I believe that this case is distinguishable and the statute is distinguishable from the proportionality cases involving in Graham that don't involve child sex offenses or offenses against children. And I would start by trying to narrow the category of what it means by mere solicitation. Solicitation is a word that can have multiple meanings, and it's absolutely essential to any argument that the Kansas sentencing structure is disproportionate in the specific category of solicitation. First of all, because the legislature made solicitation in the aggravated indecent liberties a specific category of aggravated indecent liberties. So the legislature has recognized it's serious. And the other is solicitation, in this case, is the asking of a child to commit a prohibited sex act, which would be different fundamentally than saying, here, help me rob a bank, or some other kind of solicitation that's more common when you're charging someone with solicitation of another adult. And therefore that distinguishes why you don't have the 3-step reduction in the level. It's part of the offense itself, and it's a serious offense in and of itself. I think that something that's really important in looking at the disproportionality is not ignoring the fact that there's a specific built-in departure provision in Jessica's law. Now, at trial court level, the option of a departure sentence was waived specifically, and Mr. Ruggles relied solely on his constitutional argument. If he had availed himself of that built-in statutory provision, the departure would have been, if it were granted, would have been to a level 3 felony guideline sentence, which, based on Mr. Ruggles' criminal history, would have been 94 months for the primary offense, which is much in keeping with the Exhibit A, Exhibit B guidelines that are shown in appellant's brief. And the second sentence would have been presumed 55 months. I've used the middle box in the appropriate category on both of those. So even if they were run consecutively, you still would have only had a 153-month sentence.
So you're saying he would have gotten a departure if he'd just simply asked for it?
No, I'm saying that he may have chosen, for whatever reason, to ignore the departure option, but in looking at whether or not on its face this statute constitutes legislative imposition of cruel and unusual sentencing, they built into it, look to the discretionary power of the judge to reduce this from 25 to life to a guideline sentence.
So a categorical argument can never apply. We always have to look to the case specific in this because of the option for a departure? Is that what you're suggesting?
No, I think the true categorical issue is whether or not the reduced length within a border box is part of the matrix of this isn't a 25 to life, this is 25 to life if no departure is granted. That's different. That's a far reduced potential penalty. Now, I think there's a reason, if I might venture, about why that didn't come up. If you come up and ask for a departure, you're back into the particular factors that would have weighed in the first test in Freeman. And perhaps they didn't want to go there. The other part is it's argued, at least at the trial level, trial counsel says you don't have to run these consecutive. Well, in fact, the court didn't have to run the two sentences consecutive. Again, another factor. This wasn't a mandatory 50 sentence. It was 25 to life if they don't try to call upon the court to exercise its discretion and enter a guideline sentence.
Is there any other state that includes solicitation in its definition of the principal crime, as you say that we've done here in Kansas?
You know, there's 43 states, and I tried to look some of that stuff up, and I'm not sure that there aren't a couple of states that have solicitation as part of the definition. But the problem is it's like even trying to figure out what's going on in Kansas. You have to do more than just look to Jessica's law. You have to know the entire sentencing structure and go back and look at, like in Kansas, well, which rule on solicitation applies? The Chapter 33 rule of definition of solicitation, or the fact that solicitation is included under the definition of aggravated indecent liberties? That's why...
This is a discrete question, I think, if I'm understanding it. Does any of the other Jessica's Law states include solicitation in the primary crime punishable with that?
I think I found one or two that might be based on references that I was able to follow. I looked up about 35 of these out of the 43, and I think there may be one or two where solicitation is a...
Can you tell us which ones?
Not without digging and wasting your time. I could supplement that if you wanted to. And I have two other points where I think that this is different than the Graham line of reasoning. The penological purposes that the court dealt with in Graham were related to death penalty cases and to juveniles who were subject to potential life without parole sentences. And the language in the federal cases shows that the courts were showing incredible deference to the vulnerability and even potential for rehabilitation and the reluctance to just assume that a juvenile who commits a heinous crime is therefore a heinous, irredeemable person. And therefore, they downplay the deterrent value of a really extreme sentence because juveniles, according to that train of thought, simply can't be deterred the same way that a mature adult can. And so you're not wasting your time, but it has reduced impact to try to deter by either execution or by lifetime without parole on a juvenile. And they were concerned about incapacitation for a lifetime on juveniles who might actually come to some kind of maturity about who they are. And the other was, it's obvious that through that whole train of thought that the United States Supreme Court's gone through is this hope that regardless of where they're housed or whether they're ever free again, that the juveniles have an ability to come to a better and full understanding of their real humanness and to therefore become better people however the system deals with them. I think that's different than the issue in Jessica's Law's cases, because deterrence and incapacitation are precisely intended, and the problem of rehabilitation is obvious from how the system deals with adult sex offenders against minors. There's not the same confidence that they can actually be rehabilitated and therefore deterred from future bad acts. Otherwise, you wouldn't have civil commitment. There's just a different perspective on that issue in looking at what's an appropriate sentence. And finally, the death penalty and the juvenile life without parole cases refer always to an evolving standard of decency in which they point out the history that our culture, from East Coast to West Coast, North to South, everywhere, has reduced the use of the death penalty. Many states don't have it. The restrictions on how it's imposed are great. You can't just execute willy-nilly people who are mentally ill, mentally retarded, or juveniles. All of those are an evolving standard of decency towards more, the word that ends up being used on the on the juvenile life without parole cases is moving towards being more lenient, to be more compassionate and accepting of the behavior without imposing the absolute last penalty. And in fact, I would argue that the movement towards Jessica's Law cases in the last 10 years shows that the exact opposite phenomena is happening on a cultural level. Instead of an evolving standard of decency that says treat child predators like, more leniently, the opposite is true. Use the penological intentions to show some retribution because the society, the victims, and the families want it and demand it and deserve it. Use the severe penalties to deter people from acting out sexually against children, and don't put all the eggs in the basket of rehabilitation.
But you would agree there is some limitation to that evolution, as you call it. I mean, we couldn't have looking at someone in a provocative way, or a child would satisfy the crime, that couldn't withstand a categorical challenge, would you? I mean, this is kind of the next step. This is asking. There is some limitation as to what could be lumped into what is aggravated indecent liberties, isn't there?
Well, I got to hear the arguments before. Of course there are. There's some acts that aren't as heinous as others. Some acts that aren't criminal.
Would you say that there is less culpability to solicit than to actually do? That there's a level of egregiousness, if that's a word, and that what the argument here is, if you did it, you get the same sentence as if you say, would you do it with me? And that has a little false ring to it, that those are the same level of punishment, doesn't it? I mean, that's the disproportionality inquiry.
I would agree 100%, except the departure provisions are whether intentionally or not, crafted to allow the court in particular to have hearings on departure motions and step in and say this is not the same as rape and other acts, and therefore this is a case where the 25 to life is not a fair.
Is that a departure factor? So, because it's solicitation, it's different, and therefore you should depart?
No, but
That's not a departure factor, is it?
no, but it's the kind of stuff that you would look at on what's the criteria, degree of harm, involvement of the the victim as a participant. But you're exactly right. That's not one of the explicit. If it's only solicitation.
Right.
If they were going to do that, I assume the way they would have written that statute is that that subsection A3 or whatever it is that says solicitation is a lesser offense of aggravated indecent, or is an exception to, or if you're only dealing with that, and that would have been a way to address what you just brought up. But I'm just saying there is that that vehicle, and the Supreme Court, United States Supreme Court, has had two approaches to judicial discretion. Judges need to have discretion somewhere to do just sentences, but it shouldn't be arbitrary discretion. So the problem is, are you going to end up with arbitrary discretion unless you specifically say solicitation doesn't fall within the 25? Or can you rely upon judges to make wise decisions? And since they're
And I know we're not looking at the facts underlying this case, but the factual basis for the plea that was initially given, did that include a description of the uncharged or the dismissed crimes, the rape, and because it's hard to separate the two, and then But I'm wondering how much the underlying facts played into consideration of
embarrassed to read what the factual statement at the plea hearing was, because it wasn't very well done. But on pages 12 and 13 of the plea hearing, Mr. Markle, the county attorney, describes how the case started out with a report to a school counselor and the little girl's crying, and it goes into allegations of actual physical abuse and sexual intercourse.
Okay.
And
that was included in the factual basis for that. That's what I was wondering. Okay.
Right.
Counsel, I see you're out of time. Would you like 30 seconds to wrap up, or do you think you've made your points?
I think I've made my points, unless there are any other questions.
Any more questions of counsel? Thank you.
Thank you.
Counsel relied heavily on the departure factor, and certainly if the district court had departed down to the grid, then as he said, you'd be looking at about a 10-year sentence, which is about the middle of is very much in line with what the rest of the country is doing. But a departure is a departure from the norm of the crime. It has to be something different than that crime. So we're looking at a categorical analysis. We can't look at sort of an escape hatch to say, well, in the extreme cases where it's different than what the legislature anticipated, it's in line with the rest of the country. The norm is going to be, if you ask for someone to touch another, then they're going to get 25 to life. And that's the challenge. And the escape hatch of a departure can't help them here.
Sort of makes your argument here that defendant was originally charged with rape for having sexual intercourse with this child. I think she said that all of that started when she was like age 5 and went on up. But they dropped that and convicted of solicitation and got the same sentence.
Yeah, that's a
Sort of makes your argument on disproportionality, doesn't it?
Yeah, I think there's certainly a broad spectrum of acts that fall under the Jessica's Law that you get 25 to life, from solicitation to you said as to rape.
But doesn't it serve a peniological purpose?
Incarceration certainly does. And we're certainly not saying that he should get probation. Here you go to level 3, be talking 8-9 years. But I don't know. It's difficult for me to understand the argument of when you start line drawing of when the penalty purpose stops. But 8 years for asking, that seems like a pretty severe sentence. And as well as deterrent factors, as well as rehabilitation. You go to jail, you can participate in those programs. So certainly the prison sentence does, but the grid sentence does that as well. And so I don't see that the Jessica's Law, the 25 years or life in prison, serves that. The additional time doesn't serve any additional penological purpose. That's how I would phrase it.
Any more questions of counsel? Thank you, counsel.
Thank you.
Thank you both for your arguments this morning. Court will take this matter under advisement.